Hello viewers, today we are going to discuss one of the important topic which has been widely discussed, debated, disputed and finally settled in the Supreme Court in the year 2022. That is with respect to employee eligible for drawing higher pension. So let us decode this higher pension. What is this? Basically, the pension was introduced through Employees Provident Fund and Miscellaneous Provisions Act 1952 under section 6A in the year 1995. So what does this 6A speaks? It empowers the central government to issue a notification to bring about a scheme called Employees Pension Scheme to provide benefit to the employees on superannuation, retirement, permanent disablement, widow pension, children's orphan pension, etc. Further, under section 6A, it also provides that the pension scheme can be modified, altered prospectively or retrospectively. In addition to this, section 7A empowers the central government through a notification in the official gazette can prospectively and retrospectively modify the scheme. Right. So this employee pension scheme as it stood from 1995 till 2014 was different. In the year 2014, an amendment was brought out on various counts. So what was the provision before this amendment? Let's understand that first. Then we will go for what is that amendment. So under Employee Pension Scheme, para 11, subclause 1 says the pensionable salary shall be the average monthly pay drawn in any manner, including on piece rate basis during contributory period of service in a span of 12 months preceding the date of exit. Okay, that is para 11 subclause 1. What does para 11 subclause 3 says? It says maximum pensionable salary will be restricted to 6,500 per month. And subsequently, in the year 1996, an additional clause was introduced to provide for higher pension. Subject to the provision, if both employer and employee had opted for a higher pension by contributing 8.33% on higher salary, whichever is later will make them eligible for higher pension. Para 6 subclause A, which discusses with respect to who can be a member of the pension scheme. It says who on or after 16th November 1995 becomes a member of the Employees Provident Fund Scheme 1952 shall automatically become a member of the pension scheme as well. Right. So what we have so far discussed, we have discussed when was this pension introduced, section 6A provision we have discussed, section 7 also we have discussed. Then the employee pension scheme, para 11 subclause 1, what does it say? Para 11 subclause 3 provision, then para 6 subclause A of pension scheme were discussed. Now, this was disputed in the courts. Okay, this is before the amendment I am talking. Okay, this itself was disputed in the court. What was the dispute? R.C. Gupta case which is originating from Himachal Pradesh HC, where the division bench overruled the order of the single judge of the Himachal Pradesh, allowing pension contribution of 8.33% on actual salary as against the EPFO, restricting the contribution limit to maximum 6,500. We have discussed here, right? Para 11.3. This was allowed by a single judge in HC, and the division bench overruled the single judge, and finally it went to the Hon'ble Supreme Court. The Supreme Court upheld the single judge, and SLP was upheld, and RC Gupta was given the benefit. This was in 2000. By the time the judgment came, it was 2015. In the meantime, after framing of the scheme in 1995, adding this provision in 1996, is the issue that was considered. What was the plea? The plea was the employee who retired, the RC Gupta, who retired in 2005, took a plea that the new provision under clause 11.3 for higher contribution, time limit towards pension, was not brought out to the knowledge under this circumstance when an employer contributing higher pension. When they were contributing higher pension, the time limit was not brought out to them. This was rejected by the Provident Fund on the ground that the cutoff date exercise was over, so the cutoff date was over, so he is not eligible. Agreed by the order, he approached the High Court. The single judge concurred with the submission of the appellant, Mr. RC Gupta. However, the division bench overruled it. Finally, the Supreme Court upheld the contention. So, what was the crux of that judgment? Let's look into that. How the SC has analyzed this RC Gupta case. So, what did it look at? Clause 11, subclause 3 of pension scheme. So, what again I am reading, we are reading this again and again for a better clarity, so that we will be understanding what happened prior 2014 amendment, and we are going to also discuss the SC judgment post amendment 2014 in line with this. So what does this para 11 subclause 3 says? The maximum pensionable salary shall be limited to 6,500 rupees, provided that if at the option of the employer and employee, contribution can be paid exceeding 6,500 rupees per month from the date of commencement of the scheme, or whichever is earlier. This was the point. So, reading the provision, the court held that the reference to the date of commencement of the scheme, or the date on which the salary exceeding the ceiling limit, or the dates from which the option to exercise or to be renewed with the calculation of pensionable salary, the said dates are not the cutoff dates to determine the eligibility of the employer and employee to indicate their option under clause 11 subclause 3 of pension scheme. The court held that. Similar view was taken by SC in the year 2019. This was when the post amendment of 2014, the same scenario is going to come. In the matter coming from Kerala, it was a Kerala High Court judgment which came to again Supreme Court in 2019. The Supreme Court took the same view. In that, the Employees Provident Fund organization also quoted para 26.6 of the Employees Provident Fund scheme. It's not pension scheme, please understand. So what does this original Provident Fund scheme says? Clause 26 subclause 6, notwithstanding anything contained in this paragraph, an officer not below the rank of an assistant Provident Fund commissioner may, on the joint request in writing of an employee of a factory or other establishment to which the scheme applies, and his employer enroll such employee as a member or allow him to contribute more than 6,500 rupees of his pay per month if he is already a member of the fund, and thereupon such employee shall be entitled to the benefit and shall, subject to the conditions of the fund, provide that the employer give an undertaking in writing that he shall pay the administrative charges payable and shall comply with the statutory provision in respect of such employee. So this is primarily to deal with what? Provident fund contribution. So you can make higher contribution also. So the Provident Fund Commissioner argued that the appellant employee in this case had already exercised their option under paragraph 26(6) of the Employees Provident Fund Scheme. So they cannot now ask for this relief. The court held that if both the employer and employee are contributing above the wage ceiling limit, the exercise of option under paragraph 26(6) is inevitable. They have already contributed and it is going there to their fund. So it is inevitable. The court further held that when the contribution is already above the ceiling limit, how the Provident Fund Commissioner would have been aggrieved to file this SLP, and said that all that he could have done is to move the requisite contribution required an adjustment between the funds from Provident Fund to Pension Fund. Correct. What was the Kerala Division Bench held? Examined. What did it examine? It examined the following. Employee who had exercised the option under proviso to para 11(3). In 11(3), what does it say? The employee can exercise the option of 1990 scheme and continue to be in service till 1st September. Now we are going to discuss the amendment, because this Kerala High Court judgment was post amendment. Okay. So what did it say? Employee who had exercised the option and continued to be in employment. Then it also considered employee who had not exercised the option and continued to be in service. Employee who had retired prior to 1st September exercising the option. Employee who had retired prior 1st September without exercising the option. These are the four things that it considered. The matter then again came to the Supreme Court. The Supreme Court in 2019 also upheld. Then it was the central government which filed a review petition. All those things came into the Supreme Court. November SC judgment was as follows. This case is primarily to deal with the Kerala High Court Division Bench judgment 12th October 2018, which was upheld by this court. That is, this court means Hon'ble Supreme Court on 1st April 2019 on an SLP filed by the EPFO. The civil appeal on Kerala High Court Division Bench invalidating the notification. The bench of Kerala High Court invalidated the notification which was issued in 1st September 2014. And this review petition was taken and the central government and listed for hearing on 29 January 2021. This is the background of this second case. Basically to deal with certain amendments and modification brought out by the central government. So the Supreme Court went into to decide the applicability of these amendments. Okay, so it considered what section 6A of the Employees Provident Fund and Miscellaneous Provisions Act 1952 says, and also it considered para 6A, para 11 of Employee Pension Scheme. So what was this modification with effect from 1st September? Now you will come to understand it better. So before modification, what did we have? Para 6A. Para 6A says shall apply to every employee. Here also it says shall apply to every employee, both before and after. But a condition was introduced. What is that? What is that condition? It was saying from the date of commencement of this membership. From the date of commencement of the membership and whose pay on such day is less than or equal to 15,000 rupees from the date of such membership. What does it say? It says that Here there is no condition. Here it brings about a condition. What does it say? And whose pay on such a date, on joining the date, is less than or equal to 15,000 rupees, then he is eligible to join this pension scheme. Earlier it said that every person who is a member of the Provident Fund will automatically become the member of the pension fund. But this amendment brought out puts a cap, saying that any member who is joining as of 1st September 2014 and drawing less than 15,000 or equal to 15,000 salary alone will be a member of this pension fund. In essence, anyone who is drawing salary above 15,000 rupees and contributing on that will be out of pension fund, and on the entire contribution will go to the Provident Fund. This is very important. Okay. Now comes para 11. What was para 11 before and after modification? We will look at. Para 11 clause, subclause 1 says that the pensionable salary shall be of last 12 months average salary just before retirement. The amendment has now come as last 60 months average salary just before retirement, and also restricting it to 6,500 rupees or 15,000 rupees as the case may be. This modification has come. Then one more modification. What is that? The maximum pensionable salary was restricted to 6,500 rupees as on 1996. This is the important one. No, subject to the provision we said the employer and employee can contribute over and above the ceiling was there. That was removed. You can see here. The maximum pensionable salary shall be restricted to only 15,000 rupees. Then a new clause was introduced. What was the clause? Para 11, subclause 4. The existing member as on first day of September. So the members who are existing as on that day, who at the option of both employer and employee has been contributing on a salary exceeding 6,500, may on a fresh option within 6 months from this date of the amendment can opt for a higher contribution to the pension fund on a salary exceeding 15,000 rupees, and also contribute and 1.16% on salary exceeding 15,000 rupees. So what it said, the member who are already contributing and continuing to be in service should use a fresh option. Whether you opted there or not, it says you have to opt again to be eligible. So these were the amendments. The Supreme Court went into all these things and passed the following judgment. We quote below. What did it say? The provision contained in the notification dated 22nd August 2014 are legal and valid. In essence, the amendment brought out by the Employees Provident Fund Organization effective 1st September 2014 is valid. Very, very important. That means all those amendments are valid. Now, amendment to the pension fund scheme brought out by this notification shall apply to the employees of the exempted establishment as well. That is also settled. The employees who had exercised option under the provision to paragraph 11.3 of the 1995 scheme and continue to be in service as of 1st September 2014 will be guided by the amendment provided and para 11 subclause 4 of the pension scheme. That means the people who have exercised the option under para 11.3 before the amendment will be guided by 11.4. That means if they have exercised the option there, they should have again filed a fresh option exercising it. Okay. The members of the scheme who do not exercise the option as contemplated in the proviso to para 11.3 of the pension scheme would be entitled to exercise the option under para 11.4 of the post amendment. Those who have not exercised are entitled to exercise the option in detail, because The right to exercise the option before 1st September stands crystallized in the judgment of the court in R.C. Gupta's case. So they say the right to exercise the option is crystallized in R.C. Gupta case already, because that was before this amendment. The R.C. Gupta case was there and said that there was no cutoff date, so that is getting crystallized there. The scheme as it stood before 1st September and did not provide for any cutoff date. That's what we say. Their exercise of option shall be in the nature of joint option as per clause 11.4. Okay. Since there was uncertainty, the Supreme Court has come out saying time to exercise option under paragraph 11.4 of the scheme under these circumstances shall stand extended by a further period of 4 months. We are giving this direction in exercise of our jurisdiction under Article 142 of the Constitution of India. This is what the Supreme Court said. Then further, the employees who had retired prior to 1st September without exercising any option under para 11.3 of the pre-amendment scheme have already exited from the membership thereof. They would not be entitled to the benefit of the scheme. So those did not exercise and exited are not entitled. The employees who had retired before 1st September upon exercising the option under para 11.3 joint declaration given shall be covered by the provision of para 11.3 of the pension scheme as it stood before the amendment in 2014. That means they are eligible. The requirement of the member to contribute at the rate of 1.16% of their salary to the extent of salary exceeding 15,000 rupees per month as an additional contribution under the amendment scheme is held to be ultra vires the provisions of the Act 1952. We do not find any flaw in altering the basis for computation of pensionable salary. That also they have said. We agree with the views taken by the division bench in the case of R.C. Gupta so far as interpretation of the provision to paragraph 11.3. That means it is settled. Pension scheme. The fund authorities shall implement the directives contained in the said judgment within a period of 8 weeks subject to direction contained earlier in this paragraph. That's what the Supreme Court concluded. So just to decode this Supreme Court judgment, I am trying to explain to you, though I have explained there in brief, but a detailed note I am giving here. The SC uphold the EPFO amendment in 2014. What does it mean? Government has power to amend the scheme prospectively or retrospectively. Employee joining the scheme for the first time after 1st September and contributing PF above wage ceiling 15 are not eligible for pension. 1.16% of employer contribution on account of higher contribution not valid and struck down the amendment and kept the same in abeyance for the government to come out with an alternative provision. If an employee and his employer were already making higher contribution as of 1st September 2014 and has exercised the higher pension option as per para 11.3 as it stood before the amendment and has also given the fresh joint declaration as per amendment on 1st September under para 11.4 shall be eligible for higher pension. So do you understand? So if an employee has already exercised the option under 11.3 pre-amendment and 11.4 post-amendment, he is eligible for higher pension. The next one, if an employee and his employer who are already making higher contribution as of 1st September and has not exercised the higher pension option as per 11.3 as it stood before the amendment and has not given a fresh joint declaration as per amendment of 1st September 2014 under para 11.4 and view of the R.C. Gupta judgment and of the High Court judgment on lack of clarity, the being crystallized, is given time till to file joint declaration within 4 months of this judgment of the Hon'ble Supreme Court Judgement to avail the higher pension. That means they have not exercised prior, they have also not exercised post. So they are given. Employee who had retired before 1st September 2014, now comes before retirement cases, and who contributed actual salary, which is above the CH ceiling, has exercised the option under 11.3 as it stood before the amendment, shall be eligible for higher pension. Okay. For the refund and the amount, but they have to refund the amount that they have received. They are along with interest to the department. That is why this joint option request is being now made available in the EPFO portal. Once the joint option is excised, then the calculations, other things will come. Fine. So I have tabulated below the judgment and also given an example for you all to understand better. So just decoding further through a tabulation of the SC judgment. Some joined before 2014, the scenario. All have joined before 2014 because a person joining after 2014 on a higher pension, no, because that's already approved by the Supreme Court under clause 11 subclause 6A para, right? So now the pension available for all, yes, all, because they've joined before 2014, everyone is eligible for pension. Contributing above 8.33%, is everyone contributing? No, the first option is not contributing and rest of the options are contributing, correct? So in that case, first option, all other things is not applicable for him subsequently. Okay, that means he will draw the normal pension. He is not contributing above. Only the dispute is with respect to the contributing over and above the wage ceiling limit. No. Retired before 1st September, any of them, the first four, they have not retired, but someone has retired. Yes, he is joined before and retired. Yes, there are two options to join. So joint option, pre-amendment under 11.3, the first person will not, because he is not above wage ceiling limit contribution. So the rest of the persons, option is 2 and 3 exercise the option, 4 does not exercise the option, 5 does not exercise the option. The person who retired exercise the option. Now joint option post amendment, not applicable for the first option because he is contributing only up to the wage ceiling. Second, yes, he has exercised the option. So he has exercised the option under pre-amendment and post-amendment. This third option he has exercised, but he did not exercise the post-amendment option. The fourth person has neither exercised the option under 11.3 nor 11.4. This is where the crystallizing the judgment using R.C. Gupta. It's called a green corridor. I have called it as a green corridor. So next one, retired, 11.3 has not exercised, so 11.4 is not applicable to him because he is retired before 1st September. For the last person also, the option 6 also, he has also retired before 1st September, so it's not applicable to him. So based on this, the SC time limit extension and eligibility comes to for whom? The first option, because he is within this wage ceiling, is not applicable. The second one, this extension time is not applicable because he already exercised the option, so he is continuing to enjoy that benefit, so there is no dispute. The third one is the important one, who is continuing in service, who has exercised before 11 amendment but not later, means that he has not opted for a pension, so he is not eligible. The fourth one, he has not exercised at 11.3 or 11.4 because of this disputes in the various courts and the Supreme Court judgment. The green corridor was given for these people, and yes, they are eligible. And the last two persons who were retired prior September, where the first person exercised before amendment, the first person did not exercise the provision and retired, he won't. The last person exercised the provision, he is eligible. Right? So the pensionable salary, what will be the pensionable salary in these scenarios? First person, he is contributing only as per wage ceiling, so 6,000, 15,000. Second fellow, he has done always pre and post amendment, so his actual salary will be coming here. Third fellow person option, he will not be eligible because of the conditions, so he will go to up to wage ceiling. Fourth option, yes, special option, eligible on higher salary. He's already contributing, so all funds will be reallocated to the pension fund. Fifth option, retired, earlier excised but now not excised, his wage ceiling is close to 6,500 and 15,000. Sixth option, last and final option, he is excised. After retirement he contested it, he couldn't get it, so he will get, and he will have to refund that money whichever he has received in order to facilitate for higher pension. So what I am saying here is, first one is ruled out, so he is out of wage higher pension because under wage ceiling is. Option 2 and 3, the employee who had exercised option under the proviso to paragraph 11(3) of the 1995 scheme and continue to be in service as of 1st September will be guided by the amended provision. That means 11(4) says fresh option have to be exercised, because 2 and 3, what happened, 2 exercised the option, 3 did not, so they don't qualify. Option 4, there was uncertainty as regard validity of the post amendment scheme, which was quashed by the judgment of the 3 high courts. All the employees who did not exercise the option but were entitled to do so could not due to the interpretation of the court. So that is why this green corridor, they have not exercised, so they are getting that option to exercise the option for higher pension. Option 5, the employee who had retired prior to 1st September without exercising the option under para 11(3) before the amendment, he is not eligible. And para 6, option 6, the employee who has retired before 1st September exercising the option but was not denied, this is the person who has contested the case and he has got this relief. Right? So moving forward, as I said, employee drawing salary above 15,000 joining for the first time after 1st September is not eligible for pension as per para 6E of pension scheme that we have discussed. Employee falling under option 6, what they have to do, have to refund the amount received towards provident fund to the extent it belongs to the pension fund along with the interest. That the EPFO will calculate and send once the option is exercised. So using this judgment, I have just tabulated a calculation to understand things even further better. See, date of joining, what everyone has joined in every option is, and 1st January 1996 is the joining date option. PF salary for all of them are under high, all of PF salary. Okay, contribution, wage ceiling, but the first person is contributing only as per wage ceiling. Contributing more he is not doing, but rest of the people are contributing above, means that is he is restricting himself to wage ceiling. That means he is contributing this amount on 6,500, after the amendment 15,000 as the case may be, 2 contributions. So both of them are contributing because here they are all excised, so they are getting it. Now, retired before 1st September, none of them retired except this last 2 category which we have discussed. Eligible for higher pension as per SC? No, because we have seen here at the top, right? Here we have seen no eligibility criteria. What does it say? Not applicable, not applicable. No, yes, no, yes. So same thing will come over here. That's not applicable. Where is this? Eligibility. No, yes, because we will no, yes, no, yes. Okay. So pensionable salary before 2014 proportionate calculation, pensionable salary post amendment, because the pension salary ceiling limit was increased. So this is how it works. Date of retirement. Say suppose they have retired on 30th June 2023. What will be the situation? Years of service. Right. Up to 2014, how many years of service? All of them have rendered. 19 years. Years of service post 2014 amendment. How many years? All of them have rendered, except last 2 who have retired before, so they are 0. Rest of them are 9 years. So total pensionable salary is 27 for all except last 2. Then please also recollect that a person who has rendered more than 20 years of service, he will be eligible for 2 years as bonus. That's also there. So total pensionable service for all of the category is here. pension factor is 70. So pro rata pension is calculated up to 2014. What would be the pension? Pro rata pension after 2014. Who is eligible? He is eligible because he is within the ceiling. He is eligible on a higher pension. He is eligible only as per wage ceiling. He is eligible on a higher pension. Lost to? No, because they have retired. He can't. So total pension, each category will differ according to the option they have exercised in compliance with the Hon'ble Supreme Court Judgement. Hope this is clear to all of you. Now you are able to understand how